Welcome to Washington Legal Foundation's briefing. My name is Glenn Lammi. I am the Executive Director and Vice President for Legal Studies at the Foundation. We're pleased that you've chosen to use about an hour of your busy day with us. As you know, WLF is one of the more active amicus filers in the Supreme Court among public interest legal groups. This was a really up and down term for us. On the one hand, of the 13 petitions WLF supported for acceptance and argument this term, the court granted 6 of them, which is a record we're quite proud of considering the overall rate of cert grants. On the other hand, the court dismissed as improvidently granted 3 of those cases after oral arguments. So that was definitely a downer for us. We also saw positive results in 3 cases, including 2 where we filed at the cert stage as well, and the court ruled against us in 3 others. So we're kind of like the beginning of an NHL hockey team's record, 3-3-3. The term overall was, I think, a really typically interesting one with a quite impactful final day, highlighted by a major opinion on a case that came to the court, to quote Justice Kavanaugh, in an interim before the interim basis. Our panelists will delve into that outcome and more, so let me briefly introduce them. Morgan Ratner is a member of Sullivan and Cromwell's Supreme Court and appellate practice. Prior to joining the firm, Morgan served in the Office of the Solicitor General at the U.S. Department of Justice. During her tenure there, she argued 8 Supreme Court cases. She clerked for Chief Justice John Roberts and Judge Brett Kavanaugh when he was on the U.S. Court of Appeals for the D.C. Circuit. Christopher Michel is a partner with Quinn, Emanuel, Urquhart, and Sullivan, where he serves as co-chair of the National Appellate Practice. He's argued 11 cases in the U.S. Supreme Court. He also previously served in the Office of the Solicitor General at DOJ and also clerked for Chief Justice John Roberts and for D.C. Circuit Judge Brett Kavanaugh. Jessica Ellsworth is a partner with Hogan Lovells and co-heads the firm's Supreme Court and appellate practice. Having argued 85 appeals, she focuses her practice on the Supreme Court and courts of appeals. Jess served as a judicial clerk for Judge Martha Craig Daughtry of the U.S. Court of Appeals for the Sixth Circuit and Judge Rebecca Beach Smith for the U.S. District Court for the Eastern District of Virginia. I'll note to viewers that this program is being recorded. If you have questions, you're welcome to ask them using the Q&A function in the Zoom webinar toolbar. We'll get to those towards the end. And if by chance you're watching this as a recorded video on our YouTube channel, please like and subscribe. So in preparing for this program, I went back and looked at the questions I did for last term's review. And the first few of questions of that term review focused on whether the 2023 term's decision expanded the power of the judiciary. So it seems appropriate then to start today's program talking about the Trump versus Casa decision and its impact on the power of the executive branch vis-a-vis the judiciary. Chris, is this the dramatic reshuffling of the balance of authority in our 3-branch system that some of the initial commentary claims it to be?
Well, thanks, Glenn. I think the answer to that question, as is often the case, kind of depends on your perspective. If you're looking at the view from 1789 to the present, then, I don't think this is much of a reshuffling. The situation after the Trump v. Casa opinion is, as Justice Barrett's opinion said, the one that prevailed for about 95% of our country's history, which is that district courts generally did not enter nationwide injunctions, except in a few very specific areas. If, by contrast, your perspective is for the last 10 or 15 years, then this does have the potential to be a pretty significant change because over the last 10 or 15 years, nationwide injunctions have become increasingly prevalent, including in administrations of all political backgrounds and in district courts of all political backgrounds. Not surprisingly, there's a certain set of district courts that tend to have entered them against a certain set of administrations, and vice versa, as the opinion laid out. I think we'll talk more today about some of the exceptions that the opinion discusses, and so it is too simplistic to say that nationwide injunctions are done as a general matter. There are still a number of mechanisms by which parties can obtain that kind of relief, but I do think it will be a big change from the recent past. One other part of the opinion that stood out to me that I think is relevant to this, though, is that the Supreme Court itself, even in cases that don't involve nationwide injunctions, the Supreme Court itself will continue to make nationwide law. I think this was sort of the purpose of Justice Kavanaugh's concurrence, to explain that when the Supreme Court, for example, says that a certain action is likely unconstitutional on the merits in ruling on a nationwide injunction, that ruling will still have nationwide effect as at least as a practical matter, even if it's issued in a case that doesn't involve a nationwide injunction as a legal matter. And so I think, that's a nuance that I'm not sure has been fully captured in the discussion afterward. In the commentariat, but I think that's an important limitation on the decision's practical effect going forward.
Thanks, Chris. So, Morgan, in addition to not ruling on the merits of the Trump administration executive order, Justice Barrett's majority opinion left open the viability of states' parents patriae standing and the use of federal class actions to pursue injunctive relief. What are your thoughts on those open questions?
Yeah, thanks, Glenn, and it's great to be here. I just to give a little bit of a step back for those who might not have carefully followed every piece of that question. I think the court effectively left open two paths to get to the same result in this case. One of those is suits by states, and that's really requires two things. It requires these states to have standing to bring this sort of suit, and it requires a nationwide injunction to be necessary to afford those states complete relief. So that's option one. And then option two, as you said, is a class action that would seek injunctive relief, presumably on behalf of a class that covers everyone that this universal injunction would have. The court didn't give us guidance on either of those. And at first I thought, how could they not say anything about this? And then I remembered the very strange emergency posture that this case arose in. This was not a normal case on the merits docket. It was an application for a stay. These were not pretty booklet briefs with the right colors on them, right? They were a couple pages on these really meaty issues that had to be filed. The government filed its reply in one day. So in retrospect, perhaps not surprising that the court didn't say all too much. So I'll give, I guess, a high level of a couple things that lower courts might say. On option one, on the state side, I think there really is a question whether this is a true parents patriae suit, or whether this is a case in which the states are really suffering their own harms. This is a circumstance in which there are a lot of administrability issues. Someone having a social security number or not goes to a lot of what the state does. And so I think what we're going to see lower courts grapple with is, well, are these states trying to come in and bring suits on their citizens' behalf? Or are they really just complaining about sort of their own injuries? And I think here it's possible that the answer will be that they really are complaining about their own injuries, but that answer might not be the same in a lot of these other universal injunction cases. So we might get an answer here that makes this case look like maybe not a big deal, but it might be different in other cases, right? On the same thing on the class action side, you've got all these requirements: numerosity, commonality, typicality, adequacy. You've got the requirement under B2, which is an injunctive class, that the injunction has to be kind of generally appropriate. And I think you might have reasonably strong arguments for class treatment in a case like this. But again, that could be, sort of potentially misleading about the importance of the opinion, going to what Chris was saying, because the outcome here might be the same. But there are a lot of these cases where universal injunctions have arisen where it's really not going to be equally susceptible to class treatment. So the way I think of it at the end of the day is you can have really broad relief sometimes, and this case might be a good candidate for broad relief on one of those two grounds. But we have to remember that these types of injunctions are kind of outside the norm, and you really have to do more work if you want to justify getting there.
Thanks, Morgan. So Justice Barrett explained in a footnote that the court also isn't going to resolve whether federal courts can vacate an agency action under the APA. How does that open question play into the future of efforts to try to stall executive action?
I think it's a good question that lots of us are thinking about, Glenn, because of course executive branch action comes in all different forms. These cases were about executive orders, and Justice Barrett's decision goes out of its way to say that it's not resolving this separate issue of vacatur under the APA and whether it can have a similar functional effect as a universal injunction. The court, in really parsing the Judiciary Act of 1789, is very focused on the language there, and the language of the APA is different. The language of the APA speaks about setting aside agency action that is unlawful. It has a provision that specifically allows courts to stay the effective date of agency action. And this is something that Justice Kavanaugh flagged right up front in his concurrence, pointing out this language. So I think there is this open question, Justice Kavanaugh's view that cases under the APA allow plaintiffs to ask a court to set aside an agency rule might not be universal. And I would note that a couple years ago, in a case called United States v. Texas, Justices Gorsuch, Thomas, and Barrett said that it was an open question and serious enough to warrant careful consideration as to whether there really can be vacatur of an agency rulemaking. So I think that the jury is still out on that one. We have to watch it as the case law continues to develop.
Thanks. Chris, a coalition of trade groups filed an amicus brief in CASA urging the court to continue to allow universal injunctions. How does this decision in the end, you think, impact the business community?
Yeah, I think that's something that's going to be interesting to follow in the years ahead. As you pointed out, there was that one amicus brief that argued in favor of nationwide injunctions. I assume that's because, the businesses that filed that explained that they need, businesses that have multi-state operations, benefit from having uniformity, nationwide uniformity, and so nationwide injunctions are helpful to them. I thought it was interesting that the Chamber of Commerce filed a different amicus brief in the case in support of neither party, making the point that the court should recognize representational standing. In other words, when a group sues on behalf of all of its members, the relief can run to all of its members. The court, I don't think, addressed that issue directly because it wasn't really presented directly in this case. But one outcome could be that there are more suits by business associational groups like the Chamber of Commerce or others that are able to achieve broad relief for a broad group of members. That, of course, could tee up more questions about this representational standing issue that the Chamber raised. The other point I would reiterate, though, is Justice Kavanaugh's point, which is that even in a case where you have a party-specific injunction as opposed to a nationwide injunction, if that issue is important enough to make it to the Supreme Court in the preliminary posture on the emergency docket, then you will get what amounts to a nationwide, you could at least get what amounts to a nationwide ruling on the issue. He, in his opinion, singled out the Clean Power Plan and the OSHA vaccine mandate as examples, both of which were brought by business groups, among others. So I do think there's a chance that for the most important cases business groups want to bring, even if they can't get nationwide injunctions, there's still a mechanism to get nationwide answers.
Just so with Justice Kavanaugh talking about that in his concurrence about the Supreme Court obviously being able to issue a nationwide opinion at an interim stage, do you anticipate a growth in the court dealing with these sort of before the interim stage cases? And is this a good use of the court's time?
So I think Justice Kavanaugh is exactly right in pointing out that nationwide injunction cases don't stop with a district court decision, because injunctions are immediately appealable, whether you get them or not. And so all of these cases do make their way pretty quickly through the Court of Appeals and onto the SCOTUS docket. And I think the way he put it was to say that order of operations will not change. Cases will continue to move quickly up with or without nationwide injunctions. What's interesting, and Chris mentioned this a little bit, is that he really does spell out this view that there should be a nationally uniform answer on whether a new statute or a new rule or an executive order is enforceable throughout the United States. He even recognizes that it's not workable, not sustainable, not desirable to have some kind of patchwork scheme for the years that these cases take to get decided on the merits. He just really doesn't think the uniform answer can come from the district court. And I think that's a little bit confusing, because if a case comes up to the Supreme Court for review of an injunction that's only applicable to the parties in the case, whether the court grants or doesn't grant a stay, that injunction is going to remain only applicable to the parties in the case. It's not like the court can turn it into a nationwide injunction. Now, I think, and this is, I think, consistent with what Chris was saying, the practical effect may be broader than the parties in the case. But, I was struck a little bit by the somewhat glib nature of giving a uniform answer when you are insisting that the injunction that comes up before you is actually not a nationally applicable injunction. I don't know if it's a good use of the court's time, but I think it is where we are, and the court is signaling loud and clear that the new normal is that the court expects to be deciding whether new statutes, new rules, executive orders can take effect while they're litigated, and that's what we're going to be dealing with for the foreseeable future.
Thanks, Jess. We could go on and on, I'm sure, about the CASA case, but we have some other cases to deal with, so I'm going to move on to some other ones. So the judiciary's ability to check the executive branch was implicated in a number of other decisions this term, including one decided on the final day as well, FCC versus Consumer Research. Morgan, what does that decision portend for the so-called non-delegation doctrine?
So this is a fabulously interesting case. I filed an amicus brief on behalf of the Chamber of Commerce. I'm not representing its views here. Here's what makes it so interesting to me, is the majority basically writes its way out of a non-delegation problem. And in doing so, I think it really recognizes that the non-delegation doctrine and these principles are not toothless. And so everyone seems to agree, or at least a majority of the court seems to agree, that if the statute at issue just said to the FCC, go and make a more equitable world of communications services, then I think you would have a majority that says, no, that's not constitutional under the non-delegation doctrine. And maybe at times you could have read this statute as veering in that direction, but the court doesn't take that reading. Instead, it sort of construes it tightly wherever it can. When it says sufficient, then sufficient is both a floor and a ceiling. When it gives a list of considerations for the agency, well, those are actually, a checklist that have to be met, not just things that go in the hopper to be considered. And so it's almost as a matter of constitutional avoidance. The court construes the statute like a little more tightly than the FCC itself had traditionally read it. And so I think it gives a really powerful illustration of what the new non-delegation doctrine is going to be. The court doesn't want to strike down statutes on non-delegation grounds, but a majority of the court doesn't want to say that non-delegation is a totally toothless doctrine. And so I really think that after this opinion, we're going to see it morphing into something similar to how parties use the major question doctrine as a statutory interpretation tool. And the argument will be, read this statute this way, constrain agency discretion in this way, because if you don't, it's going to start creeping towards some very hard to pin down non-delegation line. And so the fact that the justices in the majority and the dissent ultimately more or less agree on the non-delegation principles and just take the fight to the text, I think is going to be a really good template of how this tool is used in future cases.
In the court's Monday order, the court sent back quite a few cases back to the appeals courts based on the outcome in the consumer research case. So it'll be interesting to follow those cases as they go forward. A business's success in challenging an administrative agency's action can depend on where they file that challenge. The court addressed that question in 2 environmental cases and one involving FDA's review of the so-called electronic nicotine delivery systems. Chris, can you briefly note what the court decided in those 2 Clean Air Act cases and then delve a bit more into the RJR vapor case?
Sure. Yeah. So the two Clean Air Act cases were both about where certain challenges to EPA Clean Air Act determinations should need to be filed. And the statute has basically two parts. One says that the challenger can file in the DC circuit or the circuit where the challenged action is based, and then it has a sort of exception provision that says if EPA bases its decision on a nationwide determination, then that challenge has to be filed in the DC circuit. So EPA, both of these cases involved what might be described simply as bundled actions that EPA had taken. In one case, denying certain hardship relief exceptions to small refiners, and in the other case, denying certain state implementation plans, SIPs, that were proposed by states. And in both cases, the court, in opinions by Justice Thomas, he wrote both of these opinions, rejected EPA's lead argument that by bundling these decisions together, it could get into the DC circuit, because EPA said by bundling them together, we've made a nationwide determination. The court said, no, you can't do that. That would allow EPA to essentially evade the venue statute. You have to look at what the EPA action is actually based on. And in both of those cases, it was based on regional decisions, one for the small refiners in whatever region they came from, and one for the states who were bringing the SIP challenges. But then the court proceeded in each case to the second step to decide whether the nationwide determination exception was triggered, and split the difference in that on that issue. In the small refiners case, the court said that exception was triggered because EPA had relied on a federal statutory interpretation and a nationwide study as the primary factor in denying the hardship relief petitions. And so that case was properly brought, should have been brought in the DC circuit. In the other case, the SIP cases, the court said that EPA had relied on state-specific factors as opposed to nationwide factors, even though it had some, the nationwide determinations were somewhere in the picture. They were not the focus of the EPA actions, and so those were properly left in the regional circuits. So kind of a mixed bag on that across those cases. In the FDA case, this was about who can bring a suit under a statute called the Tobacco Control Act. It essentially says that anyone adversely affected by a specified FDA decision can bring such a suit. In this case, it was about an approval for certain e-cigarette products. And the question was whether retailers of those products could bring a suit, or only the manufacturer, who was the subject of the denial order, could. And the court said, in an opinion by Justice Barrett, that adversely affected is a broad statutory term that covers the retailers as well as the manufacturers, because the retailers, if the product is not approved, the retailers can't sell it, and they are adversely affected within the ordinary meaning of that term and within the more specialized meaning that the court has given that term in the APA and other statutes. So although that case only pertains to the Tobacco Control Act, I think it's more broadly applicable to businesses in that it reinforces the court's broad understanding of the term adversely affected, which is in the APA. But it's also a bit of a double-edged sword for businesses, because that same term appears in some statutes like the Fair Housing Act and Title VII, in which businesses are often defendants, and construing that language more broadly allows for more suits to be brought against businesses. So on balance, I think it's a mixed result for business, but a good result for broader access to the federal courts.
Thank you, Chris. The court also issued two opinions this term in which the question of deference to an agency determination arose. The first involved an FCC interpretation of the Telephone Consumer Protection Act, which is a subject of quite a bit of private litigation, and whether a district court should defer to that interpretation in a class action lawsuit. Jess, how did that one come out?
Yeah, so I was looking at the statistics that came out earlier this week on the way the court lineups for various opinions were. This is one of 15% of cases that were 6-3 decisions. This one was authored by Justice Kavanaugh with the 3 more liberal justices in dissent. It is a case that is about this kind of long-running interpretation of the Hobbs Act, which always had been that appellate courts have exclusive jurisdiction to resolve challenges brought to FCC orders. Those challenges have to be brought in 60 days. And district courts in this private TCPA litigation would apply the FCC interpretation of the TCPA. And that was the way it had been for a long time coming up. But the court took a different view and held that the Hobbs Act does not actually require district courts to defer to the FCC orders when they're interpreting the TCPA in a civil action. One of the big issues, and it was the one that was at issue in McLaughlin, is this determination by the FCC that online faxes are not covered by the statute. That is, one of the many rules that the FCC has put out there that I think in many cases have been taken as given when you're in the midst of a battle over whether the TCPA applies in a particular case or not. In a lot of ways, I think the court's ruling is consistent with Loper-Bright. It is really assigning the role of definitively interpreting statutes to courts and courts only, and limiting the role of agencies in having a final say on what a statute means. The upshoot of this ruling is that there's really no finality even for what might be quite dated FCC interpretations at this point in time.
So what was interesting about this case was that the plaintiff was supporting the notion that courts should ignore the Hobbs Act basically and bring their own interpretations. So do you think that the McLaughlin decision is going to lead to a rise in TCPA litigation and more circuit splits over the differing interpretations of FCC rules, really neither of which bodes well for business defendants?
I think it is likely to lead to more TCPA litigation. It's also likely to lead to lots more debate in those suits because there are aspects of the FCC's rulemakings here and FCC interpretations that plaintiffs in TCPA cases like more. There are a whole other set of similar FCC determinations that defendants like more. But now anyone who disagrees with the FCC ruling has an opportunity to challenge it in litigation. So I think there's going to be a wide range of both offensive and defensive new legal arguments we're going to see in TCPA cases. All these statutory interpretation questions that may have been perceived as being foreclosed are really now up for grabs. It seems inevitable that will lead to more circuit splits over time, that it will lead to more litigation, at least in the short term, while some of these work their way through the system and reach some ultimate conclusion about where they land.
So the other case on interpretation involved the National Environmental Policy Act. The case was 7 County Infrastructure Coalition, where the court unanimously held that judges should confer substantial deference to agencies when addressing the adequacy of environmental impact statements and environmental assessments under NEPA. Chris, how does that outcome square with McLaughlin and then also with Loper-Bright from last term that dictate courts should find the statute's best interpretation?
Thanks, Quinn. Yeah, this was a very interesting case, and I will also, maybe if I can do this on the fly, try to field a Q&A question that came through, which is, are these in fact law school books on my shelf? And the answer is yes. And right here is my legislation and regulation book from Bill Eskridge when I was in law school. And it's here for 2 reasons. One is that my wife doesn't want me to have all these books at home, and so they had to go somewhere. And the other is that they're occasionally helpful in going through cases. So a lot of that legislation and regulation book is about Chevron, and I didn't actually tear the pages out at the end of last term, but a fair number of them are less relevant than they were when I took that class back when I was in law school. But one decision that is in that book and that I think explains Justice Kavanaugh's opinion for the court in this 7 county case is the State Farm decision. And State Farm basically says that courts will defer to agencies when they're making policy decisions or applying law to fact when Congress has clearly delegated to them authority to do so. And there was a very important passage in the Loper-Bright opinion last term that said State Farm is still good law when there are delegations like necessary and appropriate or similar terminology to agencies. The court will continue to defer to agencies when they are applying those kind of delegations in fact finding. The classic example is, for example, the EPA when it decides how many parts per million of mercury are allowed to be in the air. The court has made very clear it's not going to review on its own as a de novo matter how many parts per million of mercury should be in the air. The question is just, did the EPA comply with all the procedural requirements that are imposed by the APA? And I think that's this opinion is an important confirmation that principle, the State Farm principle, survives Loper-Bright and survives cases like McLaughlin that, as a general matter, decline to defer to agencies' legal interpretations. Here, the NEPA, the NEPA statute, gives the agency a lot of deference in reviewing certain permitting decisions and in determining what the environmental impact of a particular project is. And the opinion explains that the court is not going to second guess the inputs that the agency takes into account. In this case, it was whether a railroad, what needed to be included in the environmental impact statement for a railroad in Utah. And the court gave a lot of deference to the agency in deciding what to consider or not consider. So I think this is an important reaffirmation post Loper-Bright that when agencies do that kind of work subject to a delegation, that's one, not challenged under the non-delegation doctrine, and two, not involving legal interpretation, there'll still be robust deference to agencies in those cases.
Thanks, Chris. So we mentioned the issue of standing a little bit when we were talking about the CASA case. Standing to sue was front and center in two major business cases this term. The first one is one that Morgan worked on for the victorious petitioner in the Diamond Alternative case. Morgan, what did the court decide there?
Sure. So let me give the standard caveat that not speaking on the client's behalf now. There's a specific holding and a more general one. The specific holding is about California's emission standards for cars. California has this special permission under federal statutes that it and only it gets to ask for a waiver from preemption to set certain rules related to car emissions. It got a waiver here, and the car manufacturers did not challenge the rules, but liquid fuel producers and others in the liquid fuel industry did so. And the DC Circuit tossed this on standing on redressability grounds. And it said, look, there's a possibility we don't have the car manufacturers here. Maybe they would behave exactly the same way, even if there were not these rules that California had laid down about emissions and electric vehicles and the like. And the Supreme Court's specific holding was, no, let's use a little common sense here. The whole reason that we have these rules, that California enacts these rules, that EPA allows them, that the parties fight about it for years is because they actually do something. And that's the whole reason the government is regulating. And what they do is they push the market to use less liquid fuel. So that's the very specific holding. The more general one for WLF and for this audience, the more general takeaway is this. Sometimes regulations operate through one industry, but are really targeted at another. And the sort of infamous New York soda ban is the one I like to think about for this, right? New York City said movie theaters can't sell sodas that are really big. That operates on movie theaters. But obviously the people it's targeting, what the government really cares about, is reducing soda consumption. It's the soda companies who are really the ones that are hurt. And I think more generally what this Diamond case will now stand for is, in the ordinary course, if the government operates through one industry to kind of get to the other industry, and you're the target, you're going to be able to rely on some common inferences. If you're the soda company, you're going to be able to say, hey, the whole point of this rule is to make movie theaters sell less soda and have people drink less soda, so I'm hurt, and that's redressable. And so I think that's an important principle that will be drawn from this, which is the government doesn't get to sort of regulate through somebody else and then say, aha, we have no idea whether our regulation is actually doing anything. Maybe it's just the market. This should be an arrow in regulated parties' quiver.
Thanks. The justices ended up digging the other case that involves standing, LabCorp versus Davis. Morgan, as somebody whose practice involves high-stakes litigation, do you share WLF's disappointment that the issue of uninjured plaintiffs will continue to kick around the lower courts until another case gets back up to the Supreme Court, which we hope is soon?
I sure do, Glenn. I mean, it seems to me like it would be great to have an answer, and the court probably could have said something. I mean, Justice Kavanaugh laid out a way of reading the procedural history here. Maybe the court buys it, maybe they don't, but that could have been sorted out on remand. It had been great to have a general principle laid down by the court, even if that doesn't actually constrain this case because the district court does something else on remand. And so, I think it'd be nice in a circumstance like this if the court, after having had all the investment of resources, was just, spent the time to give us a decision, even if it turns out to be kind of maybe not outcome determinative in that case. But I think, frankly, and others may have views on this, the court has shown lately a greater willingness to kick core business cases for sort of perceived footfalls. And I think this was one of them.
Chris, Jess, you'd like to comment on that at all in terms of what Morgan said about kicking out business cases?
Well, sure. There were two others kicked out this year, and they were both business cases. They were, in fact, both securities cases. The court sort of negated its securities docket, without much fanfare in the fall. There was one called one that was brought by Facebook or Meta, and one that was brought by NVIDIA, both of which had potential to clarify the law on what I viewed as relatively important securities questions. I filed an amicus brief in the NVIDIA case on behalf of a law professor and a business school professor at Stanford, arguing in support of bringing greater clarity to the Private Securities Litigation Reform Act provisions that were at issue in that case. But alas, it was not to be in that or the Facebook case, which had to do with the scope of omissions liability under the securities laws. And the court, as is typical, did not explain why it digged these cases. And in fact, we know even less about these than we do about LabCorp, because there was no separate opinion in these cases like there was from Justice Kavanaugh in that case. I think my guess from reading the argument transcripts and the speculation is that the court, was having a hard time drawing a sharp line of the kind that the petitioners in each of those two cases were asking for, and the court must have felt like it was going to be simply deciding each case on its own facts in a way that doesn't really befit the Supreme Court's exercise of jurisdiction. It frankly seems to me that there was not a jurisdictional problem, or at least it wasn't obvious that there was a jurisdictional problem in either one of those cases. It was more just sort of second thoughts from the court after having heard the arguments. And obviously, they're entitled to do that if they don't think the case is worth their time. But it is disappointing for the private bar and the business community not to get answers. I will say, for those of us in the Supreme Court practice world, keep an eye on the general questions presented in those cases, because it's always nice to be able to say in a cert petition, you granted this question once before, and you had to dig it, but this case doesn't have the problems that led you to dig last time, as far as we can tell. So hopefully those cases will get back there. Those questions will get back there before too long.
Wise counsel of making lemonade out of lemons, Chris. Jess, any thoughts on the courts issuing these kind of digs got to be very frustrating for advocates and certainly for the parties themselves who invest all this money in getting a case to the Supreme Court only to have it kicked out after oral argument, especially.
I think it is disappointing, and in candor, we represented NVIDIA in that case, so can say specifically that it's disappointing for parties when that happens. I think when the court put in place its process of trying to relist cases before grants, it has been trying to eliminate situations like this from coming up. But sure enough, there were 3 of them that came up this year. That does seem like a pretty high number for the court, and they did happen to be business cases. Time will tell. It may just be a coincidence. That seems most likely to me, that there were just specific things about these 3 cases that led them to do that. But for all the investment that gets put into it from the parties, from all the amici, really to tee up what are some important legal concepts to get resolution on, it's definitely disappointing. Oops.
Sorry. Jess, thank you. Circling back to the emergency docket, the court granted the government's request to stay a district court's judgment in a challenge brought by Merit Systems Protection Bureau and NLRB commissioners. What do you think that portends for the viability of the Humphreys executor precedent going forward?
I don't think it bodes particularly well for it. There were only 3 dissents from the stay here. The stay does reserve the ultimate issue of whether these commissioners are within a recognized exception to the general rules about a president removing officers who are exercising power on his behalf. That full question, of course, is going to get full briefing and argument, but with the stay decision, it does, it's hard to read it and not feel a little bit like the writing's on the wall. And the thing that struck me about this one is it's not the first time in recent years that we've seen the court grant a stay petition where the party seeking a stay is actually not arguing that the lower court misapplied existing law, but is instead trying to overturn or seek a change in existing law. And given the factors that the court usually looks to in assessing a stay, it is, there's no factor on there that says you can seek a stay and we can grant a stay if what we're going to do is endorse or signal that there should be changes to existing law. But the fact that they have done this in a few cases, I think, will contribute to more parties being willing to seek stay requests that do seek just that. And that means more pressure on the court to make fast decisions without full briefing on these important questions about whether certain precedents should be overruled or narrowed, and that this could come up more in the shadow docket as a result.
There was a decision today from the Fourth Circuit that refused to stay or refused to overturn the district court's stay of an application of its decision to a challenge brought by fired consumer CPSC. I guess all these agencies messed up. Consumer the CPSC. We'll just leave it at that. So that's going to create, I think, another opportunity to get the issue up there as well. Question for anybody who'd like to address it. The statistics from this term show that the court reversed all 8 appeals from the Fourth Circuit, which I guess is apropos to what I just said about what happened in the CPSC case, and 10 of 13 from the Fifth Circuit. What kind of insights do you think can be drawn from how those circuits fared this term? And I'll open that up to anybody who'd like to answer it.
I'm happy to start. I mean, I guess I'll speak in defense of both of those courts quickly, which is, as a reminder, no circuit does better than 50%, right? And so nobody's getting a great score here. With a shout out to SCOTUS blog Stack Pack, I saw the 9th Circuit was 0 for 4, the 10th Circuit was 0 for 5. So in terms of losing rates, I'm not sure that either of these circuits is doing all too bad compared to their peers. In terms of why there are so many cases, I think that people are being really selective with forums when they have the opportunities to control them. Take the RJR case that Chris talked about earlier. And so you are getting more big cases filed in the Fifth Circuit, which is perceived as the most conservative circuit, and in the Fourth Circuit, which although some people are still thinking of the Ninth Circuit, really the fourth, first DC circuits are probably now perceived as the most left-leaning. And so I think you see more cases coming out of there because you see more big cases filed there, and in both directions. And it's, and the cases the court takes, it often takes to reverse.
Yes, Chris, any thoughts?
I agree with essentially everything Morgan said. I think the overall reversal rate this year from the court was about 75%, and they affirmed in 25%. So, that's consistent with the idea that lots of the cases they're taking because they think there was a problem with the way it was decided below, and that is how they ultimately come out. But, I think time will tell how the Fourth and Fifth Circuit do in the coming terms. I feel like every circuit probably has its moment in the spotlight where they don't do so well, and they hope to improve that record the next time around.
Yeah, no, I agree with all of that. Some of these are just kind of happenstance. I think that the cases happen. Sometimes the court, for example, will be resolving a circuit split, and it just happens to be the most recent circuit. But as Morgan pointed out, it's not an accident. There are a lot of challenges of a certain type filed in each of those courts. I mean, I think taking a step or two back, it's pretty remarkable, for those of us who went to law school when probably all of us did, that the Fourth Circuit is now, viewed as a relatively friendly circuit for more liberal challenges. It's certainly not how it was 15 or 20 years ago, and the Fifth Circuit is what it is now. So, it just goes to show you things can change over time. And on that Fifth Circuit record, I will say, I think one of those affirmances was in the Free Speech Coalition case. That was a case that I was involved in representing the challengers. And although that does go in the books as an affirmance, the court, I think, expressly said we reject the reasoning of the Fifth Circuit and upheld the decision on pretty different grounds than the Fifth Circuit did. So I'm all for scoring, wins where you can find them, but that one maybe is a little generous too.
Reminder of viewers that if you have questions, please feel free to ask them. Starting with Chris, what cases or pending cert petitions should advocates for free enterprise like WLF be watching out for the next term?
Sure. Well, I'll take the opportunity to shamelessly plug one of my pending petitions for next term. This is a petition that I filed on behalf of Cisco Systems, the internet company, and we are challenging a Ninth Circuit decision applying the Alien Tort Statute to the claims in that case, which I won't give you all the details, but ultimately challenge conduct by the Chinese government that Cisco allegedly aided and abetted. And to make a long story short, our argument is that there is no aiding and abetting under the Alien Tort Statute. We got 7 judges to dissent on the Ninth Circuit, and a lot of good amicus support at the cert stage, including from WLF, which we're very grateful for, and the Chamber of Commerce and some other business groups. So the court has taken a number of these ATS cases over the last 20 years. The court has signaled in its most recent ATS case that it might be open to some changes in that area. And the court CVSG'd, called for the views of the Solicitor General on the case, which is another sign that hopefully it's taking the petition seriously. So that would be an important business case that we very much hope reaches the docket next term.
Thank you. Morgan, Jess, any thoughts?
I'll go next, and I'm going to shamelessly plug a cert petition that Morgan is actually advancing right now. It's the Duke Energy petition coming out of the Fourth Circuit. It's a case where the Fourth Circuit, applying this monopoly broth theory, added up lawful business practices, more lawful business practices, more lawful business practices, and found that amounted to anti-competitive conduct in violation of the antitrust laws. So that's also one where there's been a CVSG. I think it is really important to the business community to get some resolution on this idea that acting lawfully plus lawfully plus lawfully somehow is unlawful. So that's one of the ones I'm going to watch this fall.
And I'd add on top of that, the court recently granted in a case called Cox Communications against Sony, which is a pretty interesting question of whether internet service providers can be held contributorily liable for copyright infringement if they basically don't cut off bad actors who they have been informed about. And I think this is interesting in part because we've seen this notion of secondary liability keep bubbling up. It was up in the Twitter case 2 terms ago. It was at issue in the Smith & Wesson case this last term. Now this is the copyright twist. And this continues to be something that companies are dealing with, I think, because the court has not wanted to draw super clear lines about when kind of inaction can make you complicit in someone else's bad behavior.
Chris, thanks for plugging the WLF involvement in the Alien Tort Statute case. I also note one that WLF is supporting with an amicus brief that Uber filed in a case called Uber versus Drame, where the issue of eerie guess is in that case. And if you don't know what eerie guess is, please go ahead and read our amicus brief. None of us here knew what eerie guess meant either. So I guess it's one of those things that you have to be out there doing a lot of litigation at the state level to understand what it is. So we have a couple of questions from online viewers. I will get to the first one here, which is, do any of the panelists think that the CASA opinion portends a potential challenge on constitutional grounds to APA vacatur, given its discussion in several arguments last term? Anyone have thoughts on that?
Well, I don't think Justice Kavanaugh is going to be on board with that argument, given his position in this case and his corner post opinion and his questions at the argument in the Texas case that Jess referenced earlier. You could still countify without him, but it is hard to countify without him, as the stat pack that Morgan referenced showed. I think he was in the majority 92% of the time or something like that this year. So I think there are certainly some interesting arguments on that front, but I'd be a little surprised to see that argument make too much headway.
Okay. Other question from an online viewer. I'm interested in the panel's observations of Justice Jackson this term and her dissents on both the emergency docket and the merits docket that criticize both the procedures and operations of the emergency docket and the substance of the court's ruling. Is this distinct from her role in past terms? Is she writing more often and more critically? How does this compare to other junior justices in the past? Anyone like to take that one on?
I'll say a couple things. I do not have hard data to back this up, but I do not get the sense that this is a big shift from year over year. She has the last couple of years consistently been the most vocal justice at oral argument and at or near the top in terms of opinion writings. I think this term she was right behind Justice Thomas, who is, extremely prolific. I think that is different from junior justices in the past who often take a little time to find their footing. But she's sort of marked herself early in her career as willing to say what she thinks, willing to be a solo dissenter. Again, if she's going to be writing as much as Justice Thomas, we may have the two of them as kind of counterpoints on the spectrum with a lot of diverse views in cases. So I think she's not changing, but she's sort of found her footing maybe faster than other justices historically.
Thank you, Morgan. Separately, why does the panel think Chief Justice Roberts assigned the nationwide injunctions ruling to Justice Barrett? Anyone want to hazard thoughts on that?
I think I don't know. Short answer, I don't know. I think it's a fascinating question. I think it certainly didn't hurt that she's was a federal court scholar in her prior life before going on the Seventh Circuit, and so was particularly well qualified to write that opinion. As her opinion notes, several of the other justices had already addressed that question in separate opinions, so there may have been something to the idea that it was helpful to have. I think some of them at least had suggested that there was a constitutional dimension to the foreclosure of nationwide injunctions, and that may have been tough for them to write an opinion along the lines that the court ended up going. So she was a good choice for that reason. I think we've all observed. I think the Chief Justice does strive, to give good opinions, important opinions to a range of justices, and I think this is probably the most important opinion that Justice Barrett has had in her time on the court, and I imagined he welcomed the chance to give her a big one like this.
So certainly, we all became more familiar with the academic writings of Professor Bray, thanks to the fact that Justice Barrett wrote the opinion. So another question from an online viewer. Can the panelists who clerked at the Supreme Court explain, discuss how opinions are written, compared, edited, finalized from one justice to another? Do most initial drafts come from clerks? Our former SCOTUS clerks like to take a crack at that?
Yeah, I mean, I think most of the justices have law clerks draft opinions. I think there's probably some variability in whether any of that draft survives to what is ultimately the opinion. And I think justices handle it in different ways, just the same way that, now that I'm at a law firm practicing and I get drafts from associates, some people edit in an iterative fashion, right? So the law clerks give them a draft, they make some changes, maybe they tweak it here and there, and they do that again and again 20 times until it's effectively all in their voice. I think some other, and the 20 times is not a joke for at least both of the judges that I clerked for, judge and justice. And I think others of them take it and sort of have it sitting there and then kind of rewrite from scratch in their own voice, but use it as a helpful way potentially to organize their thinking or the research and the like. So everyone starts with something from their law clerks, and I think everyone ends with something that's basically in their own voice, and how they get there might just change a little bit justice to justice.
Chris, Jess, anything you'd like to add to that?
Well, I clerked for the same two justices that Morgan did, so it's a similar story, and I can say one of the great parts of that experience was just watching them and learning from their approach to editing drafts, and Justice Kavanaugh used to edit in a Sharpie marker, and you would know that it was a bad sign when he came into your office and the page smelled like Sharpie. There were a lot of edits on the draft. The chief, by contrast, liked to edit in pencil, and he would sometimes he had a lot of edits when there was like a page stapled, to the back of the draft. It would say, insert A, and then, there'd be like 3 pages of handwritten stuff to insert, invariably, written pitch perfectly. So, going through that iterative process was, so helpful, and still influences my legal writing today.
Well, thank you to our viewer that asked that. It's always nice to get those sort of anecdotes out there. So I'm going to ask one final question as the moderator, for the benefit of our reporters that are online. A letter was sent to the justices, I think last month, asking them to broadcast the audio of the announcement of opinions. They've been doing the broadcast of the oral arguments, obviously, since COVID. And there are some instances where there's announcements of opinions and then they have oral arguments, and some of the oral arguments start late because they are introducing the opinions. Do any of you think that the justices are going to agree to do that?
I don't know. I would have not thought, if you had asked me this question 10 years ago, or maybe even, what was it before COVID, 6 years ago, that the court was going to go to live audio. It wasn't quite over the dead body of Justice Souter, as he said at the time. It was when he would allow cameras into the courtroom. But live audio was pretty, seemed like a stretch until it was sort of forced on the court by the pandemic. It's hard to see exactly how that would happen here. But I think, live audio has been a good thing for the court, at least as a practitioner. I think it's really valuable to be able to listen to argument in real time without being in the courtroom. I love to be in the courtroom, but I can't do it every time. I can't spend sort of 3 hours, sitting there every morning, given obligations to other clients. So I think there would be a a benefit to the public to doing that. I imagine the court is a little hesitant to do anything that takes away from the opinion, the written opinion's finality. But with appropriate caveats, I think that could be overcome. But I don't know. The court changes slowly, so I wouldn't bet on it anytime soon.
Yes.
I agree with that. I will say, having argued a case last year that was decided while I was in the middle of trying to pick my kids up from swim team practice, when my phone started buzzing and I was frantically trying to stick them in the car and get them buckled in. I personally would be very in favor of avoiding that situation by having the live oral argument. But I agree with Chris. It may or may not come down the road, but I think there are lots of us who would enjoy being able to tune into that when it happens.
I think we can safely say it's more likely that they give live audio of hand downs than of cameras in the courtroom. So we can probably all agree.
Agreed.
With that.
So one of our audience members noted that that's actually a letter that was sent last year to the justices, and it was just made public this last month. And he had said there's been no answer so far to the letter. So, and he doesn't expect we'll hear one anytime soon. Your anecdote just reminded me about the fact that during one of WLF's wrap-ups on the Supreme Court, like right in the middle of it, is when Justice Kennedy announced he was retiring, and somebody had gotten it on their phone. This was when we actually did programs at WLF's office in person pre-COVID, and that ended up being like a 10-minute long discussion in the middle of the program because obviously you need to talk about that if you're reviewing the Supreme Court. Thank you, Chris, Morgan, and Jess for joining us today. And thank you to everyone who took their time to join us live. As I said at the outset, it's going to be available as a YouTube video later on. And when you sign off today, if you have a minute or so to take a very short survey on your enjoyment or lack of the program, I definitely appreciate it. Thank you, everyone, again, and everybody have a great 4th and a wonderful summer.
Thanks, Glenn. Bye.